Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. This is the place where we talk about domain name legal news, and we also review some recent UDRP decisions. There's three hosts to this show: myself, Todd Ryan, David Michaels, and Jeff Neuman. I'd like to say hi to my co-host before we get rolling. Hi, David. How's everything going with you today?
All right, except for having a little trouble getting a name out of Epic. Other than that, it's going great. It's a really sunny day.
Yeah, we'll talk a little bit about some industry news before we get rolling here on our cases. Jeff is at some depositions today. You guys might know, or he's mentioned it before, that he's representing some parties that are on basically filed a lawsuit against GoDaddy because of some clawbacks on some domain names. So Jeff is busy taking some depositions today, and it's going to be interesting. We'll talk about what he's working on when he comes back next week, and we have some good cases already lined up for next week. This week we have three good cases too: redmountain.com, stinger.com, and betbra.com. But there was several pieces of news that I wanted to get to, and some of it's legal news that we'll probably get to next week, and I mean in detail, because there was a piece of news that came out today by Gigalaw, that's Doug Eisenberg's company. It's basically saying that UDRPs were actually down for 2025, when I thought we already went over some data that showed that the UDRPs were up. But anyway, UDRP decisions from all providers were down, well, basically 8,476 decisions in 2025, 8,484, so down by 8, just 8, the number 8, in 2024. So I thought, didn't we go over some things, David? There was more, it seemed like there were more cases filed. So maybe when this decision, I'm going to look into it, but maybe it means some cases were filed and then withdrawn because the respondents decided just to go ahead and transfer the name before a decision was made. But actually, so 8 less decisions in 25 than 24. Does that surprise you, David?
I'm not sure one way or the other, but either way, it's a lot. I think a lot of these cases are abusive. We'll talk about the first one too. Yeah, the first one was like really abusive. Actually, the first and the last one was super abusive.
Yeah, and there was plenty of other news that, you guys know on Thursday, Josh and I do a room, Domain Name Investing. It's DNX show. But there we have more time, and we go over really anything that's domain name related, because anything that's domain name related usually affects the investment side of domain names. So there was a lot of news. I was thinking about, people have been talking for the last couple of weeks of that AI.com purchase. And then I guess, that was purchased by the guys that run crypto.com. And then they end up buying, I guess, OG.com for their predictive markets at the same time. And there wasn't a price. But it got overshadowed by the $70 million price of AI.com. But Mark Mojica brought up that it was, I guess, OpenAI had purchased, was it Clawbot? What the name is this? Is it Clawbot, or it's actually OpenClaw? And I just read that OpenAI also bought Prism.app. So we're seeing a lot of consolidation in that now. We're seeing some big players make some big moves, or at least try to, I'm not going to say even solidify their space in AI. It looks like, everybody talking about, well, they have a seat at the table now since they bought AI.com. Certainly you could say that. As a domain investor, I think it's fantastic for us. But, I was reading, David, do you happen to see a Snagged? I believe it was the guy who runs Snagged, Rob. I believe it was Rob, I'm sure it was, who posted. He was talking about a negotiation. Basically, he had a customer that wanted to buy a domain name. The seller, the domain owner, didn't didn't agree to a price and has been went from like 50,000 up to 700,000. Basically, he's continuously raised his price, and Rob was saying that he felt like this domain owner is targeting the potential buyer, and this potential buyer is done, not even interested in it. Um, I don't know why I'm bringing that up. I had some thoughts on it, but David, did you see
I know
that?
it's not on the agenda, but I can tell you that that type of behavior is normal amongst people who don't tolerate low ballers. So, if the price is 250 and you're offering 10K, like you're nowhere near, and they're just going to keep on increasing the price until you like either pay up or go away because they don't think you're serious.
Yeah, and I think if Rob knew that, say that was well, he would if somebody like Rick Schwartz, who you know he wouldn't offer it for that low anyway. I mean, have it even initially offered it with a buy it now price that low. There's some people that will think, okay, now it's millions, like you said, David. Okay, you wanted to offer this. I didn't even know anybody had any interest in it. Okay, I don't need to sell anything. But I was also thinking about this company in China owns CAI.com, and they own a ton of other great names, but they happen to own CAI. I don't know who it is, but big domain investor. But it made me think about Rick Schwartz, Domain King, when I'm thinking there's so many people that own two-letter names. I mean, Rick has made his uh, built a reputation in this space and made a name for himself. But when it comes to portfolios, his portfolio really, can't hold a candle to fucking. I can think of 20 people that have, and the people that I know, let alone all the ones that we don't know. And you always hear in this space too, and I'll talk more about it on Thursday, I think, because it's more of me ranting of, all the big sales from Drew Rosner to Shane Coltra saying, all the stuff's not reported. We know. Okay, so there's all these 5, 6, 7, 8-figure names, 8-figure sales aren't reported all the time. And we hear about it. They want you to know, man, you guys don't even know. You fucking commoners out there, domain investors, you guys don't know. There's big things happening all the time. So, of course, this is the biggest reported sale, 70 million, but there's just big sales all the time going on. And it made me think when Rob at Snagged was saying, yeah, it isn't okay to have a view if you're like somebody who's not one of us, a domain investor. I've always been able to have the view as like if I wasn't a domain investor, because now I'm less and less a domain investor. I have 1,000 names, used to have 5, 6,000, that I think, yeah, domain investors, they think their shit's worth a lot. And you know what? When I'm a domain investor and I can side with them, yeah, our stuff is worth a lot. Even a crappy 2 or 3 word name, yeah, may want 700,000. So I jump back and forth all the time, but I can certainly say domain investors think if you don't have my name, you can't build your dream. Not in this category. And then they think their names are worth so much, and then um, they, basically, even if they have a low cost basis, they want 2,000, 3,000 times their cost for the name. And you absolutely can have that stance if you're the one that owns it and you think, listen, I don't care if you guys don't think this land's worth anything. It has no power on it, it has no sun on it, and it's in the fucking bad side of the mountain. If that
Okay,
owner
okay, but
believes
you know what?
yeah, good.
There is a lot of cases where somebody has a name. There has been no interest on it. He doesn't monitor his portfolio. He doesn't know what's going on in the marketplace, and all of a sudden these brokers are emailing him, say, "Hey, here's an offer. Here's 5,000 for your name, or here's 8,000, or here's 60,000." Like think about those kind of names, and then what these brokers are doing? They're buying it for other domainers, and then those names get relisted for like 10x, 100x. That's a lot what Drew Rosner does, or either he's doing that for himself, for his clients, or he's either selling to end users or resellers. They're in that business. There are a lot of brokers who do that, and so yeah, you might have a whole lot of names and there's no interest in them until there is, and that's when the jackpot strikes. So people hold out. They have a right to hold out. It's their property. There's like we'll talk about in the first case. Um, the offer was 5,000, but the guy paid 10,000 for it. So why are you filing a UDRP? You think it's not worth 100,000? that's the whole problem. People don't know what it's worth, and some people just want to hold out until they find out what's going on.
And you're talking a bit about our first case, the Red Mountain case. We'll get to it in just a second. But yeah, somebody who owns the name thinks there's millions of companies that have it. I believe my name's worth hundreds of thousands. And then, of course, the person buying it's like, and we're going to get to that case where they offered 5,000. The guy had bought it in the aftermarket for 10,000. But sometimes buyers think, you guys just have these domain names, and just now it's 50,000. And now, of course, they just keep going up in price. And then, of course, all of us domainers, we could all just band together and say, we'll never sell a domain. Like Rick Schwartz went, never sell a domain for less than a sign would cost, 30,000, 50,000. But then you get guys selling names for $400, $600, because they're thinking, fuck that, man. I'm not with you guys at the poker table. Just either win the tournament. All I'm trying to do is buy names for 10, $20, flip some for 400 or 500. I live over here in Indonesia, and it does mean something to me. I don't need to live in fucking Million Mile Mar, whatever the fuck it is, in Florida.
Okay, but you know why? If
Yeah.
your sell-through rate's less than 10%, that doesn't work. The math doesn't work.
Well, yeah, if you're having a terrible, sell-through rate. But listen, first I was going to say, everyone needs to know domain investing is really personal. You can hear all the stories about, I believe some of the brokers are having their best times ever. There's some brokers that aren't selling shit. Arif came on stage, and we're going to talk to him in just a second. He may be profitable. It doesn't mean you're going to be profitable. And I was listening the other day to Arif, and he was even mentioning the first 3 or 4 years that he did it, didn't have a sale. Well, how much were you spending those first 3 or 4 years? 5,000, 10,000, 20. So you spend 30, 40,000, and then you finally start making some sales, and you're profitable that first year, 20,000. The first year that you've been making sales. Well, yeah, but you're already in the hole. So a lot of people are in the hole, and they don't let you know over the whole course of time. It might take many, many years before you're in the green or red, whichever one's the fucking profitable. And then it's just look at your own situation, and even if the guy's next to you, like, I'm in a business where people make money. If you're one of the real estate brokers that doesn't sell houses, fuck all the other people that are doing well. And what I mean is, it can be an indication that oh, some people do cash in at these poker tournaments. So I know, and I know they're average guys. It's not all, it's not a big fix that's in. But if, it's personal. If you're not making money at it, okay, the guy that is profitable, that doesn't pay your bills. And, sometimes you can have very similar names, but your portfolio for some reason is, you do need some luck, but maybe you aren't listing your names, across all the places, or, you have the different lander, or you don't have buy it now. But my point is, there's a lot of folks, when I watch the shows, when I'm talking about Sherpa now, and I was thinking about, of course you don't want to hear from guys that aren't making sales, but when it's always, better than ever, and no one really talks to the guys that are 95%. I think this year I've had 3 sales, 2 or 3, and I only have 1,000 names, so I only have $10,000 in renewals per year, and of course it gets some better rates. Arif, I know we normally talk about domain investing on Thursday. We're talking a little bit about it today. What comment did you have about our topic?
And keep it short in that front. Just 3 things. First of all, looking for in the black, right? Not red or green, but in the black. Second of all, I've certainly made sales in my first 3 years. It's just that after that is when I started to become a little bit more consistent in the pretty much doubling my money every year, right? So that's just to say what you're, correct a little bit what you're saying there. And after that, obviously, I folded some of those profits back in, and we'll talk about that another day because that's domain investing. I just came up because I just wanted to push back a little bit on what you're saying. It's not untrue what you're saying about like some domainers want to, really, shoot the moon, and when somebody comes to them, they want to price it as max as possible. The vast majority of profitable domainers don't fall in that category, right? Like, I mean, I know you're saying it because it's an example, but I'm just pushing back because it's like it's not typical. It's not the typical domain investor does that. It's not the typical situation. Doesn't happen. Certainly, it happens, right? But I mean, in most cases, people they want to sell their domains and they try to find an optimal price, and they the price that they think it's going to sell at, and usually if for a profitable domainer, you'll get 1% or whatever it is of your domains that fall into that category where you match your price with what a buyer's looking at, a year, and that's how you make money, right? Hopefully, you have enough of those sales, and you're profitable at the end of the year. So, I don't think most domainers really fall in that category of like overpricing, or if an offer comes in, it's like, okay, no, you have to play by my rules and all that. So no. Most of us are pretty happy that when a client comes and approaches us and we want to make a sale, and we try to find something reasonable, and yeah, we want to maximize, but it's, not to the point of like really being ultra aggressive. So I just wanted to, push back a little bit there.
Yeah, I mean, I agree with you that most people don't overprice. The ones who overprice, the ones who've been, I would say, the more experienced ones who think, listen, I know seldom do we sell a name, so when someone does come knocking, we, want a lot for it. But hey, Michael, before I get to you, I wanted to say, so here we're going to get to our cases pretty fast. We usually talk domain investing on the Thursday show, free for all, open discussion. Here, we certainly invite people to bring up legal issues or have any comments about some of the cases we're talking about. But since I've went off track a little bit, talked about some domain investing, I'm guessing you have comments on that. Michael, welcome. What comment do you have today?
Guys, when you look around, and I'm only in the game, so um, as I said to you from around last May, so I'm not as experienced as you, but I come from the entertainment industry. But what I'm asking is, when you see these big sales going around, like 70 million and all, does it not look like a Wall Street in domaining where these buyers are just basically they have these domains and they're just using money, and the money's floating around? You never think of things like that, like all of a sudden these domains are selling for this amount of money, but yeah, it's coming from big companies that are getting rid of this money, and it looks like the same people are selling around the same domains around and around again. Like, and as I said, I'm only new in this game. Like, I'm only in it since May. I've only sold 10 domains. Um, but like, I wanted to ask, in particular, there's somebody on to me about two of them, and I don't know what they do on them. Like, so I know I'll probably talk to you about that on Thursday and get a bit of advice on it, because they're they're 4L domains, and they're very, very brandable, and I can't get an accurate price on them. Like, one person is saying it's 10, another site is saying it's 15, another site is saying it's 18. I just don't know. So I'd like some time to get a bit of advice off you, because, as I said, I'm on 10 domains in nearly a year in sales. But no, I'm just coming back into what you were saying about these big sales of 70 million. When you look at it from the outside and you look into it, like, it does look like that these people are just spending this money over, and it's just going around and around. Like, it, that's what seems to me like these big sales and 70 millions in this and the other. Like, it realistically, it's unrealistic. Like, do you know what I mean? That anybody would pay that type of money for a domain, you know?
Well, let me say a few things and we'll get onto our cases. One, I almost agree with you that 70 million, if people think now there's going to be a bunch of $50 million domain sales because this one went for 70 million. All right. Well, I don't have any single words or two letters or even three letters. So, yeah, on the high end, I watch the high end of the market, and meaning like Andrew Rosner, Andrew Miller, and uh, Nat Cohen, guys who I believe sell to the high end. And when I see that they're having a lot of success or a lot of sales, it makes me, I do use that information to decide on where I think the overall market is. Because I always believe the best names are the first to go up, the last to come down. So, then you sort of find out where do you think your names are in that setup as compared to the best names. Okay, quickly, when you say the four letter, right? Here's the deal with the four letter. A four letter JQZA.com. All right, that really is, I would say, the bottom of the barrel. Meaning, okay, so if you own that, you could certainly price it at $1,995, $5,000, $10,000, $15,000. If a company, and that would probably be somebody over in Asia, because there's plenty of words and streets and geo areas that begin with Q and Z, and they at some points like those. If you happen to strike gold, get lucky, yes, you could sell a name like that for 5,000. Likely, if you know folks that have owned a lot of four letter, there's some that it'll stay in your portfolio forever. You renew, renew, renew. At one point, I owned 3,500 four letters. There's a guy that, and people act like they don't know who it is. This 4L.com guy that's on X now. It's Ryan. Okay, over in Europe. He owns a lot of different names, but he just happened to own a portfolio of 25,000. He bought a lot from me, four letter domains, because he wanted to, put them in like 5 different categories. The best ones are best letters and pronounceable. If you own YOLO.com, YOLO, you only live one, something like that, hugely valuable. Hulu, so you have names that can be hugely valuable, and then you would feel comfortable saying, I want high 5 figures, in the 6 figures, I guess a few, maybe even in the 7 figures. But when it comes to the random numbers, the random letters, those, and Ryan proved it in a lot of his data this last few years, and I knew it anyway because I've owned them, is sometimes even the shittiest letters, you will get lucky. If you price them all at $5,000, your good ones and your bad ones, the good ones are going to go much faster, but there are going to be some that you would consider not good letters. And not good letters are normally just letters that aren't used very frequently in the U.S. Europe doesn't even spend as much money. Drew talks about that in his show, that, hey, he's over in Portugal and fucking they don't want to spend any money. They're more thrifty with their spend. Businesses are, people too. But so the thing is about four letter that no one knows was when you have other domains in your portfolio that never sell, like I had some in my portfolio, never sold. Well, I still sold batches of four letter at $300 each, at $200 each. You can't do that. You can't sell 500 names at $200 each. If it's just even if it's brandable, people aren't buying them in bulk like that. So that was the main difference for me with the four letter, is when this is something that hasn't sold for me. There's hardly, probably like a lot of domains, zero value on the aftermarket. You're just waiting for an end user, but almost zero value wholesale. At least four letter, I could get out of them, and it may be a loss. It may have been a break even. It may have been a tiny profit, but like I said, at least I was like, okay, here's 500 for 200. Here's 100 for $300 each, and I sold some for less than that too. If somebody bought 1,000, I might have sold some for, well, a couple hundred. My point is, so that was the difference between a shitty four letter and a shitty other domain. A shitty other domain gets you zero. A shitty four letter is going to get you at least $80 or $100 on Name Pros. So that's the big difference. And people think, yeah, shitty, but no. We're about to get our cases. Michael, what do you want to say? There's somebody in the background screaming. What would you want to say?
Sorry, no, sorry, that was just calling it my son. So the 4 letters that I have there is the 2 4 letters. One of them is the NZWA. Now that comes back to the New Zealand Warm Blood Association, the New Zealand West, whatever you got. It's tied to something big as well. And then I've got the UZEG, which is tied to a college in Austria and things like that. But I have people on to me all the time looking for that. Now, when I price them on Saw saying that one is 15 and one is 14, Atom is saying one is 11 and one is 9. And then you have others saying 8, 7, this, that, and the other. Like, so this guy was on to me about buying the two of them, because to me, they're just 4 letters. They're just 4 letters. The NZWA and the UZEJ. Now I know UZEJ is big on YouTube and it's big.
Yeah. Okay. Hold on. I got to get to a show here. And I'm going to tell you, first of all, that this domainers too, the more creative you get, the different ways, the different acronyms, it doesn't fucking matter. No one, I don't care. AU means Australia. NZ means New Zealand. It doesn't fucking matter. You're going to know. When someone inquires about that name that you just mentioned, WMUZ, I don't want to know what it is. So don't come off and know. Engage with them and then get rid of it. Sell it for $2,000. Sell it for $8,000. If you think, when someone engages with you on a 4 letter like that, what I would do is, it's like a fish. Don't let it go. But when you come up with, hey, look, I owned MJNJ. That could be marijuana, New Jersey. All right. Well, it could be, but still, It's like domainers. This could mean this. This could mean this. All right, but it's most likely not going to. But you can strike gold with the ones, like I said, that are truly, in my opinion, worthwhile. Definitely CVCV, that's consonant vowel, and definitely VCVC. So vowel consonant. Those are usually pretty good, but there's some exceptions to that. People will have some bullshit ones, and you know, UM you are, and then they think, yeah, you. So go on mute, please, Michael. I'm about ready to start my show of doing the. Thank you to do we got to do these
Thank you,
reviews.
Todd. Thank you.
No sweat. We'll see you on Thursday. You can come up, and we all we do is bullshit the whole time. But if it's not those CVCV, VCVC, of course, pronounceable ones. But I got one like KROF. Is that worth anything? Yeah, there's a big company down in Australia, I think, makes fucking, what do you call it? Forks and knives and stuff. I forget what they call that. What do they call that, David? Sorry, David, you're not my assistant. I understand that. But what do they call that when all these, cutlery, yeah, stuff like that. But
Cutlery.
anyway, when you have pronounceables like KROF, well, yeah, but when you say croff, people could think it means CROF or CRFT. The point is, so I consider those with good letter domains, AMDR, I consider those valuable too, not nearly as valuable as CVCVs, but all the rest after that, they really get down to, you really need to be lucky. And if you see that a lot of companies are using that 4-letter, and I'm talking about 4-letter, not 3-letter, 4-letter is an acronym, you may have something there, but it really is random. I know a lot of folks in the crowd have invested in 4-letter. A lot of my friends here, I see them and they know sometimes, when you have the least likely one you think is going to sell sells. And I've done it numerous times, but I think 4-letter are good if you pick them up for $100 to $200, because then what you can do is ride along and see if you get lucky and sell it for in the few thousands, maybe even in the low 5 figures, and if not, then you just unload it for $100 to $200. You didn't lose all your money. You might even have made $20, and they seem to have always had a floor for the last 15 years. That floor maybe is only $100 or $150. If you got certain letters, that floor is $200, $300, $400 if they're good letters. So if you can find a 4-letter for $100, $150, $200, I think they're definitely worth the risk as compared to other domain names. All right, so there was an article. If you check out our outline, dnlshow.com, you'll see that there was an article, and now I'm not going to go over it, but it's by friend of the show. I call her Jeanette Eriksson. I had some conversations with her. Very smart. I think she's a lawyer. Very smart attorney that wrote an article. It's really long about how what's going on in the industry right now with regards to the next round of GTLDs and brands that are going to be applying, and really how I like the part of the article, and there's a link to it, about how AI is really allowing crooks to create websites and fish and do things very fast, and come up with sites that look legitimate, and they're stealing content, but also she talks about the difference between content abuse and DNS abuse. But a really interesting article, very long. Check that out. Second thing I wanted to mention was ICA this Wednesday. If you're not a member of the Internet Commerce Association, go to internetcommerce.org and join, and they're having an AMA this Wednesday with GoDaddy's broker Tom. That's Tom McCarthy, but one of the top brokers at GoDaddy, and you've heard of GoDaddy. He does a lot of deals there, and he's going to be talking about how he approaches leads, and how he handles leads, how he negotiates. And I had some questions for him too, tricks he uses to close deals. Like I said, when you get somebody that's nibbling at one of your domain names, if you're somebody with thousands of names, and even unless you got like one or two and they're just fantastic, if you got a lot of names and you get a nibble on a domain name that's never had an offer before, you want to not let that fish get away, in my opinion, most of the time. So unless they're just so far apart on the price. So we're going to talk or listen to broker Tom about on this Wednesday call. That's 10 a.m. Pacific, 1 p.m. Eastern tomorrow. That's what the ICA call. Okay, so I'll push everything else I wanted to say to next week, just topics. So we'll talk about them on the DNX show on Thursday. That's Thursday, 10 a.m. Pacific, 1 p.m. Eastern. Josh and I talk everything domain investing, and that's an open floor. Please join us, come up, and let's talk about anything related to domain investing. First case today is a domain, redmountain.com. Really interesting case. Well, I'll give a couple, just a little bit about it, David. Then I'll throw it to you, and you can just talk about the case and give the decision on it, if you will. But the complainant here is Red Mountain Med Spa. So they were out of Arizona, and they were represented by a law firm. And then the respondent was Eli Rosenberg, and he is a licensed professional, financial professional in the real estate business, and he was represented by friend of the show, John Berryhill. So this was complainant Red Mountain Med Spa filed this complaint against this individual who's a financial professional in real estate who purchased the name Red Mountain in the aftermarket in 2020 for $10,000. David, take it from there and tell us some facts about this case and your thoughts on it.
Well, the case talks about Red Mountain being a translation of the respondent's last name, Rosenberg. And it's interesting because the panelist's name is Eisenberg, and his name means Iron Mountain in German. And, so that was his statement, that's the reason why he bought it. It's the name he wanted to have for his business. But ultimately, that was not enough because it's not the same as his last name. And the other thing, though, that really helped him, I think, a lot was the fact that there are thousands of businesses named Red Mountain, 1,600 plus are currently active, and 15 trademarks in the USPTO. So there is no evidence of targeting. The complaint is a Arizona-based spa place, and their trademark is Red Mountain Med Spa. So it's not just Red Mountain, but the full thing. But they had to disclaim Med Spa. But that doesn't mean anything. There's 15 trademarks owned by 15 different owners on the USPTO. So it's a commonly used term in business. So there's no bad faith, no evidence of targeting. And the real estate agent who bought it, he actually is in the financial aspects of real estate. So he thought he would use it for his next business. And he paid $5,000 for it in 2020. And now he paid $10,000 in 2020. And now someone's offering him $5,000 for it. And he's like, no, I'll take $100,000. I'll take it in the six figures, he said. So it wasn't even a price. And the complainant says, oh, you're trying to extort us. Well, no, the name is worth a lot. What do you think?
Well, you bring up the word extort, and it's important here because John was representing the respondent here, and he wanted to get the respondent's name removed from the complaint because he's like, look, now this guy's name's always going to be, when you search his name, possibly he's a businessman, you're going to see Eli Rosenberg and extort in the same story, and this is exactly what this complainant is wanting to really cause a problem here. Unusual that a rep for a respondent requests that the name be redacted. In this case, the panelist said, no, I'm not going to do that because there's so many Eli Rosenbergs, and I don't think they were really trying to drag his name through the mud, specific like you said, John. And it is funny that you mentioned Doug Eisenberg because Doug writes Gigalaw. He's also an attorney, right? And we just mentioned him earlier about his article about UDRPs. And right, his last name means Iron Mountain. And people post on X, today's the day I learned. Yeah, I didn't even realize Rosenberg meant Red Mountain. Okay, makes sense now when I look at it. Yeah, I should have known that. If I was at Jeopardy, I would have got it because I figure things out. But so Rosenberg, Eisenberg, so we know Berg means mountain now. So this name was purchased $10,000 in 2020, and Red Mountain, the complainant, said we've had a trademark since 2015. So this person knew of our mark, and as you mentioned, David, he knew there were a lot of people using Red Mountain. And when you know a lot of people use the term Red Mountain, you have to assume that a lot of those people using it are using it. They're using it in commerce, so they're probably making money. So they probably do have a common law trademark to it, if not registered. This complainant did have a registered mark in 2015. They said, hence, then, since this was registered in 2020, the guy targeted us. Well, I wonder what they would have, if they would have known that the guy paid 10 grand, if he would have responded instead of saying, I want 6 figures when they made the $5,000 offer. If he would have said, I paid 10 grand for it, so I certainly wouldn't consider 5 grand. If he would have said something like that, I wonder if they would have said, well, we'll give you 15, we'll give you 20, because obviously 5 is too low. This gentleman who bought it, perfect reason to buy it, right? Not only is it a good domain name that you're going to use for your business, and you can think it was 10,000, pretty good. As domain investors, we know Red Mountain, pretty good. So it's perfect, investment for him. He was going to use it for his business. And then if you don't want it for your business, this name had some inherent value to it. A lot of people use that term. That's what's great about acquiring a name for your business, like Blue Mountain, Bluebird, something that when you don't want it anymore, there is some value to it, instead of coming up with, something that's rnrzenterprises.com. So when you're done, no one cares about this long name that you have. So I like that, he bought the name and he intended to use it, but when somebody made him an offer, he said, yeah, 6 figures. And that's only, John made it clear, that's only normal for somebody who's, maybe offended or says, yeah, you offer something so low, I'm going to, respond with something that may be high. And they tried to use it against him to say, that obviously shows that he's a cyber squatter if he's wanting, that much money for a domain name. In this case, John brought up RDNH, didn't request it, and the panelists did rule RDNH. So basically, this was a complaint denied. The domain owner got to keep his domain name. The panelist, Doug Eisenberg, felt that this law firm that represented the complainant should have known that just because they had a trademark 5 years before, that was just not a strong enough reason to file this case, knowing there's tons of companies that use Red Mountain as, in their company name, in their product service, and it's trademarked by many companies. John made him clear of that, and Doug didn't even really rule on the second element, rights or legitimate interest. He basically said because of the third element that they didn't prove, that we don't have to really spend time on element number 2. But I guess that's pretty much it, David. The guy did bring up,
Actually,
that passive holding.
So it's really interesting that there was a lot of back and forth in this case, and it was acrimonious. The attorneys for the complainant were really, I would say, saying bad things about John Berryhill. And, that's not professional. It's just crazy. And they should have conducted themselves better. And I think that was one of the reasons for the RDNH. But here's the thing. Even if the complainant had won this case, they're based in Arizona. The domain is registered at GoDaddy. The respondent could have just filed a ACPA case in federal court in Arizona, or even state court, and actually because it's federal court because they have a trademark, and they would have won because the name is registered in 1996, more than a decade before they got their trademark, more before they even had common law use. So they had no chance of winning. And they would have probably had to pay well into the 6 figures just for attorney's fees for that kind of case. So they should, cool their jets and say, okay, it's not ours. We don't have it. And they should know what they're doing, but they don't. And it's bad when attorneys start casting aspirations. But one thing in this case that I didn't like is that Doug Eisenberg wrote, oh, well, just because you say something doesn't mean it's true. It has to be in an affidavit, a sworn affidavit. And complainants don't normally put all their allegations in sworn affidavits. So why does the respondent have to do that? I think that is not a good policy. I think that, some panelists think that way, but I think that's a personal view that they have that's some sort of personal bias, and they should cool their jets on that too, because they're filing something in a they're verified statements. That should be good enough. Why does it have to be an affidavit? What do you think?
Well, David, I do want to address that, but I didn't see that they personally said some things about John, about his representation. I don't need to get into it, but I didn't see that they personally went after John as a domain name attorney. Did they?
Yeah, there was like 3 or 4 back and forths going on this, and Doug didn't like the fact that there has to be some finality. Like, you made your complaint, those are the facts you put forward. You can't keep changing, like arguing this and that. You made your arguments.
I see. Yeah, because they basically each side filed a supplemental filing, and of course, in a nutshell, once you file your complaint, you can't file a supplement. I mean, you can, but it's not going to be used. The panelist is going to say, is there something that must be really important that was left out? As they say, material. Excuse me. So, but when they filed a supplemental, whatever they put in there, I didn't even read what they included in their supplemental filing. I guess that must be where it was at, where they're talking about John's representation. He responded, and anyway, the panelists said, "You guys, both sides. I mean, I'm going to look at the complaint. I'm going to look at the response, your supplemental filings. I'm not going to look at, in this case, well, it was as we already mentioned, it was a transfer, and he did rule there was RD&H there. About what you were mentioning, David, I always think if you're a respondent, you're a domain owner, and if you don't have representation with a domain name lawyer, and many times you might not, because you're like, who's going after this name of mine? It's a .net, or it's just not, I don't believe it's worth me spending money on representation. I'm asking, you could be asking $2,000 for a domain name, and somebody files a UDRP against you, and you're like, I would have negotiated down to $1,500, which is what you filed for the name. So I certainly don't want to hire a lawyer for a few thousand. So I will represent myself. That's when I say you want to be truthful, but certainly say under penalty of perjury, I did not know about this trademark owner when I registered this name. And that's if you didn't know about them. If it's, but sometimes people do that when it's like a big trademark owner. You might register a name with Apple in it, and you might have rights to it, but if Apple comes after you, you don't want to say, under penalty of perjury, I've never heard of Apple. Okay. So if you've heard of the company, you don't lie, on the, but many times, I'd say the majority of times, you don't know this company from Europe that has a trademark, or this company from the East Coast when you're on the West Coast, or from the North when you're in the South of the U.S. or wherever. So if you don't know, if you have never heard of the company before, and especially when it's like, like we said, Technique Enterprises out of Minnesota, and you're like, I've never heard of them. I own Technique, whatever, ENT. That is a smart thing to do, to say under penalty of perjury, I did not know about this name this company when I registered the name. And why it holds some weight, well, according to Doug Eisenberg, this panelist, he feels like, yeah, you should, make statements like this.
I don't think it's necessary in a case like this, where there are 15 discrete trademark holders, all using Red Mountain. There's a law firm, there's E&J Gallo Wines, there's a beauty salon, there is a truck company, there's entertainment businesses. There's so many. Like, if you're not in the same line of business, then why is there a problem? You're in a different part of the country doing different things. It's a generic set of 2 words that are commonly used. Trademark should not enter that. There's no bad faith in registering this kind of name. It's different when you're registering Telstra, because there's only one country in the world that had Telstra as far as I know.
Yeah, and we know there's a Red Mountain Pizza somewhere, and what are you supposed to do? Not be able to use it? How many Tony's Pizzas are there? So that gives you an idea. A lot of us sitting here, we know there's a lot of places, Jack's Pizza, all over the place. So, unless usually those are, you coexist with another place that has the same name, and you have a right in your geographic area. Now, there's sometimes when it gets really big. What's the big pizza thing that what's the big pizza with the guy's name? I can't think of his name right now.
Papa John's?
Papa John, yeah. So I mean, I guess you could be, there's John's Pizza around places, but yeah, Papa John. Okay, we're gonna go to our next case. Let's see here. So that was a complaint denied. So John won the case, and then, like I said, he brought up RDNH but didn't request it, and the panelist went ahead and said, yeah, this was an abuse of the system for this law firm to file this case, Red Mountain. I wish they would learn some lessons, a lot of these law firms, to know when it is such a, say, popular type term that you really can't go after these terms unless you have a solid case that you were targeted, and you need to provide a lot of evidence. And even okay, so case number 2 is Stinger, Stinger.com. That's the domain name that was under dispute. Okay, so the domain was registered way back in 1998. The respondent, who is Tom DeWild, an individual, was the first, I guess, the respondent at Stinger Electronics out of the Netherlands is the company. Second respondent, it says. But the complainant, AAMP of Florida. So they do business as Stinger in the U.S. They got some products. They're like, I guess, auto product where they sell sound systems. I don't know. All I remember is they sell sound systems. And the respondent is in the auto business too, but he sells more of like radar systems. But so this complainant files this UDRP. They want the name Stinger.com. They're on Stinger. Let me see. I had it StingerDrive.com. And so they're thinking, we want Stinger. And they probably wanted it for many years. This person, the name was registered in 98, but it was acquired subsequent to that. But it was still acquired about 20 years ago, I believe. And I believe that it was part of another company. But the panelists said, no, this registration was in 98. But then the complainant said, it doesn't matter. We were incorporated. We have a registration, trademark registration from 92. So when they even got it in 98, they were aware of us. They're in the same type of business. So now we want it, this 30 years later. Well, David, Andrew Lothian was the sole panelist on this. Please share some facts about the Stinger.com case and tell us the decision.
So it looks like the respondent, Stinger Electronics BV, is registered in the Netherlands and in South Africa and New Jersey. I don't know if they're all the same entity or the branch offices, but this Florida company that filed a trademark way back in 92 and filed a complaint, they basically say they deserve the name. But okay, so this has been going on for a long time, because when the respondent applied for a trademark in the EU in 2003, the Florida company opposed it. Why? I don't know. They're not based there. They're not doing business in Europe, but they were able to oppose it because they had a registration, and you can get registrations in Europe without any use. But anyway, they got their registration in the Netherlands, where they also have an office, and that works. So that was a defense. Now, is the website active? Have you checked that? I didn't check that yet.
It says it wasn't for years and had some PPC links on it, and I think that's what.
Yeah, it is. Speed trap protection for high performance cars.
Well,
and
that sounds like
the world: Australia, Deutschland, España, yeah. Hong Kong, Netherlands. So they're a global company, and that's legitimate use. So there, Todd?
Yeah, I'm here. I was look, so this this respondent, well, to give away, the respondent did win the case. The respondent, the complaint was denied. Now, there wasn't an RDNH ruled in this thing, but because there was basically really similar to the last case, just not as strong, meaning they didn't even really rule on the respondent's rights and legitimate interest because they went back to the bad faith. And panelists always rule on it. Was there bad faith at the time of registration? Okay, the guy got it in 1998. Did he know about this business that was overseas? Right. Did he know about the Florida business? Right. Now I'm getting backwards. It was the Florida corporation was the complainant. Right. So the person over, is that right? Yeah, the complainant was the Florida corporation.
The point is there was no evidence in the complaint that showed the extent and reach of the Florida company's trademark in 1998, which is the date of the registration. And nothing suggested that the respondent would have known about it. And that's the end of it, that they had no, without that type of evidence, it's a dead, unreliable case. And stinger is like a known dictionary word.
Yeah,
so
they made it. They tried to. The complainant tried to say in this case that it was this made up word, and we know stinger. We know of a bee stinger, but it obviously, as a domain investor, we would think if you own stinger.com would be a good name to invest in. But this name was taken a long time ago. The panelists did rule in favor of the domain investor. I was trying to see, did he get who was representing the respondent? Was he did he represent himself? Looks like he might have.
No, it was somebody at legalmatters.com.
Okay, I thought that was like one
in
of
the
those self-help
so.
places. But okay, so the owner of Stinger.com got to keep the name. That case, I don't know. I had it in there because it was an interesting domain name, but pretty straightforward. It was registered so long ago, even though it was after a trademark. 98 was so long ago. Anyway, the complainant didn't show that they were well known at the time in 92. That why would this person over in Netherlands know about this Florida company that's selling car stereos? Fucking stupid. All right, this next case number 3. I want to get to this. An interesting one because I think domain owners, business owners sometimes will register defensive names, and this name is betbra.com. BetBra. Okay, I'm sure a lot of us when we saw BetBra, huh? BetBra.com. The complainant in this case owns a company called BraBet, BraBet.com, and it's basically a company that consults online gaming and betting companies out of Brazil. So that's why they come up with the BraBet, BraBet. And that's the domain that they're on, the complainant, BraBet.com. They registered this name February 2018, but they didn't acquire it until 2022. And they acquired it, they said they acquired it to be defensive because they're BraBet.com and they wanted BetBra.com and in case, basically just to be defensive so no one else gets it and tries to confuse people that they're them. In this case, the complainant was a company, the complainant was BetBra. They did create, they did register, they did finally establish a trademark with this exact name, BetBra, which is the domain name. They're the ones that are the company that trains online gaming and betting websites. So they said, we're BetBra. We want the name BetBra.com. This person that has it, the respondent, was, they're a gaming company, but they're the opposite of this. They're BraBet. So there's really no legitimate reason why they would want this name, and felt like they should have it. Now the panelist who was a sole member panelist, it was Wilson Pinero Jabur, but he ruled that it's not uncommon for companies to register names defensively, and this just swaps their, bra bet and bet bra. So the panelists really, basically believed it and said, they weren't targeting you. They were simply trying to protect their own mark and denied the complaint. David, so I went through the whole thing pretty much. There's still some of the panel's
Yeah, I just want to
analysis
add a
that we
couple
can
of
touch
things
on, but go
here.
ahead.
So crucially in this case, the evidence I got from Google Trends shows that BraBet has been well known since 2022. And that's when they registered BetBra. So that solidifies their case. And I'm on brabet.com right now, and I have a big landing page that says this game is not available in your country due to licensing regulation laws. We cannot offer our services to you. And I can contact support, but that's all I can do. And that's interesting because the complainant has a French trademark. And according to my Google Trends report, BraBet is only available in Brazil. Both the complainant and the respondent are in Brazil. So two Brazilians going at it through the white thing. And the complainant used a French trademark registration to file this case. But he also has 3 pending Brazilian trademark applications that are probably going to be opposed. There's no way he's going to allow this to happen. And because there is confusion between BraBet and BetBra. Like I've been confusing it this morning or last night, and you got confused on both of them too. So that's a good reason to have a defensive registration.
If you don't mind me coming in for 1 second, Todd, just for 1
Go
second.
ahead.
I am I'm qualified in intellectual property and data protection. A trademark mark doesn't if you want to protect your brand and you want to protect the name of your company, unless you go and take and register every single one of the classes in the trademark, you're not protected. There's nothing to stop me opening the McDonald's tomorrow across the road from McDonald's and just put a comment over the McDonald's. Once I don't have that big M, there's nothing to stop me doing that. The trademark has no, it's only if you go in and start working the exact same job. Like, so for example, if I open McDonald's tomorrow and start selling McDonald's burgers, that's where you breach the trademark. But if I'm selling a different type of thing in there, or I'm selling kebabs, that's not a breach of trademark. So as much as people think trademarks are protected, they're not protected. They're only
I'm
protected.
laughing.
Like that. I'll give you an example.
Michael, I'm
I'll give
laughing.
you
Now, hold on,
Only in North
hold on. Yeah,
America.
you're not going to be able to sell kebabs under McDonald's. I know you're thinking, but that's different.
No,
It's still going to be food. And really, I'm going to say super trademarks are different. You're not going to go out and sell Coca-Cola tennis shoes, even they're not in the tennis shoe business. Okay, so there are instances where it's a super trademark. And believe me, there are things, like I said, called a super trademark where, yeah, you sell Nike burgers. Well, I'm not saying Nike. Isn't that a Greek god or some kind of god? But there's some things you're going to be able to get away with. You're going to have to fight. But like I said, you're not selling Coca-Cola tennis shoes, even though Coca-Cola doesn't sell tennis shoes. So there's some such unique marks and such worldwide marks. So that's why McDonald's, even though that's a common last name, you really do steer clear from it. You don't have McDonald's with a big M that changes tires. Now you could have McDonald's Tire Center and have, but the point is, you're not going to. You still have to be concerned even when you're not in the same category. When you're messing with super trademarks, I will say that. But you are right. Many times, we were talking in this case, the bra bet. David's right. Listen, I was getting them confused now. The complainant and the the, the respondent, and did he really get it to protect himself? Well, it's so confusing that maybe he did because he tells people we're at bra bet, and people are like, "Is it bet bra?" The point is they are in the same category. So, Michael, you bring up a good point that there are categories with trademarks. If it's you're allowed to be Rocket Burgers, Rocket Mortgage, and so on. Okay, so that is absolutely fine to do. And there might be 2 Rocket Burgers, one in New York and one in Florida. There's even sometimes you can have the same business, like we talked about Tony's Pizza. They're all over the place. So that can happen, but you really, it's really sensitive. Every case is, as lawyers will say, every case is different, and that's why people will get say in the U.S. a registration with the USPTO, because then when there is, hey, I'm over here in Illinois and you're in Indiana, well, if one of them has a USPTO registration and has a pretty strong case, he can make the person in Illinois, you know, change the name. Now, like I said, it's case by case. But okay, so David, with regards to bet bra, it is confusing. So it does make sense to buy the other domain name, but they're both in gaming. So once again, did you think this was a complaint denied? Did you think it was a good decision here?
Yes, absolutely. And the way you can know if something is, well, it's a good decision because the French trademark was post-dated the domain acquisition. So like it was going to be lost. The complaint didn't have a chance to win this case at all. It should have been RDNH. There was just no chance of winning. But when we talk about related classes, so if we talk about betting versus consulting and betting, that is related. And there's something called coordinated classes. So if you go to uspto.gov and click on the search button and you search for trademark, there is something called coordinated. You click on that and you click on one of the classes. Say I click class 3 for face creams. Well, you know what else is related to that? Class 35, class 42, 44. And that means like that covers spas, that covers online sales. Oh, and class 21, which is housewares and glass. I don't know why that's related to class 3, but that would show up. So that's how it's done in the US, because there's some things that are related and you really need to check, is that within the natural zone of expansion? Now, there are exceptions to that between, say, beer and spirits. Usually they're not the same company that's doing that, but other things, they are quite, within the same zone of expansion. So you have a trademark for Nike for running shoes, and of course you can do sports clothing. That's related.
And of course, I'm ABC Productions. Michael, you said you were from the entertainment business. So are you a filmmaker? Are you a TV producer? Are you a musician, a magician, a juggler? What entertainment are you in from?
I was a nightclub leaseholder and a promoter. So I worked with all your friends over in America over the years, bringing in international DJs and things like that. And they do super shows and super clubs all over the country and that in the UK and Ireland.
That's
And
cool.
the reason I started speaking about the trademark is because I was taken into a big trademark case before by 7-Eleven. And they took me because I was using the brand, like I was using 7.com, even though it doesn't exist, because they were all taken out of by the what's the name of that company? Like ICANN, they took them all out of circulation 1 to 9 and things like that, and A to Z and things when they first came out. But they took it against me, saying that they had the right to use this and they were 7-Eleven. But they took the case against me. But because I showed that I had use and possession and traded as this for years, that they tried to get the .com, but they couldn't get the .com. But where I got the won the case was because I had been trading for years. So there was a book that been written, and basically then there was I was using it. I was using an IDN which translated to 7.com. So even though I couldn't physically get the domain 7.com because ICANN took it out, or ICANN took them from 1 to 9, you can't basically get 1 to 9 because of what they say, manipulation and overvaluation and this, that, and the other. So that's why they took 1 to 9 out. So I got an IDN done up, and my IDN translates identical to 7.com. So I was using this for years, and I had things registered as 7.com. I had everything done. So if basically, for example, the ICANN did ever release 1 to 9, they can never release 7, because I'd have even though they never released it, I registered, I copyright it, I trade it as it. So to them, it's useless now.
People try that all the
And
time, but
that's
that's not in U.S. courts. There's been many cases where there's some things you can't trademark. So a number, for example, you can be a number you could be 7 pizza, but you're not. But sometimes it's going to be. I mean, David, you know about this. You're not going to prevent somebody from anyway issuing the .com. That's not the reason. Anyway, you confused me with 7-Eleven and then 7, and then now no one else can use the term 7 because people try to try to get in front until you turn your company into Amazon's a good example because now Amazon there's the forest has several uses Amazon, but most people now know Amazon as the company. So they do get a lot of favor in courts when people try to come off as Amazon, and since they offer so many different types of products from different categories that Amazon's successful in various court cases I've been reading. But I mean, it's interesting. You have to look at each individual case because people do have a right to use the word Amazon in their product or service. But now they got to be more, 25 years ago, they didn't have to be careful at all using it. Now they have to be very careful using it. I don't know what you were
See,
saying.
what I done was I tied it to it. I tied the number 7, where I can understand what you say. You can't trademark the number 7, but what I done was I wrote a children's book, and it was what number 7. All the big things in the world which had a number 7. You had the 7 wonders of the world, the seven universes, the 7 deadly sins, and it was a brilliant book. But I didn't actually put the book out, but I tied the copyright to the book, and that's how I what I done. And it was a very good book. Like there was loads of things over the world that used the number 7, like so many things, and that's what it was about. Then I copyrighted to that book, so that basically put me as the official um, use of the 7, and then the book down at the end of it was the stamp at 7.com. So that's basically how I done it. So I got it through that way. And
Tons of
basically
books titled
the
Seven. I'm
case was
looking
just
at them
dropped.
right now, and the movie Seven, but I don't even know. I'd have to. That's something. I don't know. I mean, I could
You
certainly
know,
think about arguing that. Go ahead.
yeah,
New Year's Eve is the 7th day. Like there's loads of things you wouldn't believe. Like there was the 7 deadly sins, there was the 7 sisters, there was the 7 planets, there was the 7 things in Egypt. There was like there's so many things in the sevens, like with the number 7, like you wouldn't believe,
Yeah, my birthday's on the 7th. Yeah, in
Seven
September. It
days,
means
7 days. So was mine. 7 days of the week, 7 dwarfs.
we're shutting
So,
this
you know
down.
what I mean?
Who cares? Okay, so 7 sevens. Come in the DNX show, and then I doubt if Josh is going to let you up on stage with that. Michael, come in. We'll talk about domain investing. But Arif, what did you want to say before we
I will
close
I
this
indeed.
was
down?
going to quickly say that, yeah, I mean, over the years, I've heard a lot of people trying to be creative about pre-trademarking certain very short or very unique, or not unique, opposite unique, very common terms in order to capture or the domain, especially with NGTLDs as those came out or whatever it was. And most of the time they fail, right? I mean, you have a legit trademark that's accepted broadly, yeah. But I mean, you're not going to get a trademark on a single character or single letter, right? That's going to be seen as exclusive to you, right? Because in order to really say, okay, so I'm the only one who's going to be able to get this domain, it has to be seen as you have such a strong stranglehold on the mark and such a worldwide sort of knowledge of your mark and your what's the term, goodwill that you've developed, that that just doesn't exist with single characters or single letters. It's just not going to happen. It's even difficult to have on single words, which are longer words and not necessarily the most popular words, and even that's like extremely difficult. So good luck with the 7.com. One day VeriSign might put them to auction. They're not going to release them until they can sell them for millions of dollars. So that's why they're not letting them out,
Yeah.
pretty
And
much.
anytime you find there's senior users, and then you're like, well, I did that then. This guy's like, well, we did it before. There's a senior user to writing a book that has the title 7, or there's so many. Anyway, that's
And even worse is that most titles aren't even considered trademarks, right? I mean, it's like
a
titles
copyright.
are
Now,
yeah, it's a copyright, and if you have some like such huge usage in business like Star Wars, yeah, that title would be considered a trademark. But most otherwise book titles not even considered a real trademark.
hey, before we wrap up, I wanted to say, okay, I'm not a lawyer, but if you do need an IP lawyer, one practicing here in the U.S., and he's got some connections overseas, but definitely with regards to domain disputes, reach out to our co-host Jeff Neuman. He's at jjnsolutions.com. And let me know, a lot of people have domain disputes, have issues, whether it's with ICANN or whether it's with a registrar or registry or just a company that's sent you a cease and desist. But reach out to Jeff. That's at JJN Solutions. And then also our co-host that's here today, David Michaels. When you have issues with trademarks or filing for a trademark, you need some consulting work done about your business, certainly reach out to David. But David, do you want to, mention some of the services you can offer, and then I'll close it down for today.
Yeah, so I do exactly that, trademark consulting. And I'm available, David, at trademarkpro.ca. My website that's active right now is trademarkpro.org. I do searches there. Just you can pay online and order a search. And I can also do the background information required to prepare for a UDRP response in case you get hit with a UDRP complaint.
Right. It's good to get the consulting, meaning because sometimes you don't have a very strong case and you can cut it off at the pass by not even, defending yourself. But if you do have a domain that maybe is not worth hiring, spending $5,000 on, David can consult you and give you some advice for much less and send you in the right direction. If you do need like I said, a licensed attorney in the U.S., you can, get a hold of Jeff, JJN Solutions. But that's going to be it for today. On Thursday, we got a bunch of topics for the domain name investing room. That's dnxshow.com. I'm going to put up the outline tomorrow with a bunch of topics Josh and I are going to cover. That's an open discussion room, 10 a.m. Pacific, 1 p.m. Eastern on Thursday. So please join us in a couple days. Finally, I'll say once again tomorrow at 10 a.m. Pacific, 1 p.m. Eastern, there's a AMA with broker Tom from GoDaddy. It's sponsored by the ICA. So if you're an Internet Commerce Association member, I would say, hey, join us on the call. Look forward to seeing a lot of you there and asking broker Tom questions. It's a great opportunity for domain investors to talk with a professional broker out of GoDaddy, find out his strategies, some of his techniques, how he may be able to help you sell a domain name. All right. I appreciate everybody being here. Thanks. Have a good
Todd,
day.
this is a really good information, you guys, today. Really, thanks again for you guys for putting this together. I just want to say also 3 good cases today, all in favor of the domain investor. So in that side, I'm going to say it's going to be a lucky week for everybody. We're going to be all 3 for 3. We're going to make 3 sales and all that stuff. But again, thanks to you guys for really, great information that you guys put out week after week. So take care, everyone.
Yeah, thanks for all the people
Thank
being
you,
here
guys.
live
Thank
and
you.
listening to the replay. Thanks, Michael. I do appreciate you being here. I know I'm pretty rude some of the time. That's part of my shtick. All right. Thanks a lot, David, for getting me through this one. We'll have Jeff with us next week. Thanks, everyone. Have a good day wherever you're at. Good rest of the evening. Take care of yourself.